As employers begin the process of reopening workplaces, employees also have to consider what their return to work will look like. For more on that, let's bring in employment lawyer Leah Moody. Good morning, Leah. Thanks for being here.
Good morning, Neetu. Thanks for having me.
So we finally got that highly anticipated announcement from the province on what a gradual reopening of the economy will look like here. But what if an employee doesn't want to go back, even if their workplace is deemed safe? What rights do they have?
Yeah, that's certainly the big question right now, and it's understandable, and it's an important one to be asking. And I think that the first thing that's important to get across is that every employer in this province, and indeed Canada-wide, does have the obligation to maintain a safe working environment. And you, as a worker, have a right to be safe and healthy. So the short answer to the question is that it will ultimately come down to what your employer is doing to protect you rather than how you're feeling. So if you feel unsafe, but your employer is following every government recommendation to ensure your safety, you have to go back to work. If you do have a reason to feel unsafe, so say, for example, just taking an example of a government recommendation to maintain safety in the workplace, there's no ability to be physically distant, 6 feet from one another, or there's no ability or time to sanitize surfaces, then you as a worker have the right, and I would say the responsibility, to make a complaint to your employer, who would then immediately investigate that complaint.
Can an employee be penalized for making a complaint about this?
Absolutely not. That would result in what's known as a discriminatory action complaint, and the end result of that, and everybody needs to know that would result in serious fines and penalties to the employer if there's any sort of reprisal whatsoever against an employee for making a complaint about unsafe working conditions.
What about unionized environments versus non-unionized? Does that make a difference?
Not at all. Unionized or not, your employer has the exact same obligation. I would say that perhaps maybe unionized, a union will have better access to people at WorkSafe, for example, the prevention officers, the people who will come in and do an investigation of your workplace and make that determination of safety. But that's the extent of any difference there.
What kind of laws govern an employer's ability to test their workers for infectious diseases?
Well, that's certainly an open-ended question. I mean, historically, in both BC and Canada, we tend to steer away from employers having the ability to conduct random testing. But, I think that if we're talking about temperature taking, that tends to be fairly non-invasive, and it certainly stands to be seen whether or not that's going to be something that's permitted. It could be.
Right. And Leah, what advice do you have then for employers as they navigate this new normal?
The best thing that I can tell employers to do is follow the recommendations, be clear and transparent with your employees. Remember that we are all in this together. We do want to work together to bring our economy back up and running. And so follow those recommendations, make sure that people feel safe, and keep those lines of communication open.
Employment lawyer Leah Moody joining us with some very helpful insight this morning. Thanks for that, Leah.
You're welcome, Neetu.